Um, Welcome, everyone. It's so good to see a big crowd for the Richard V. Erickson lecture. I want to say a few words about Richard and the lecture series. I'll then go on and give a very short intro to our guest, Michael Byers. So the Richard V. Erickson lecture series was inaugurated in 2011 by Andrew Coyne, the national editor of Maclean's magazine. The lectures are jointly funded from the Richard V. Erickson Lecture Endowment, which honours the memory of founding principal of Green College, Richard Erickson, 1948 to 2007, world-renowned criminologist and sociologist. Richard was especially proud of his role in the creation of Green College and the unique contribution he made to building this residential academic community. I knew Richard, of course, at that time, and he's been missed greatly since his death. There's no doubt in my mind, and many of us who knew him and were here at the beginning, that the culture that we celebrate here today and both appreciate and love deeply, I think it's not too strong a way to put it, it very much depends on the beginning he gave to the college and the structures he created. So he is well remembered, and it's a little sad on each day. I'm glad to say that Richard's son Matt and his partner Samantha are here with us, and we're delighted that you can join us once again. Diana's not able to be with us this year, but very often she is. So with that, let me move to Michael. Michael is a member of the Common Room, and we are particularly grateful because he did step in about 5 weeks ago, very gracefully, when Nathalie de Rosier, who was originally scheduled to give the speech, was appointed to a judgeship and could no longer fulfill that obligation. So Michael, bless his cotton socks, as my mother would say, stepped in, and we're very, very pleased he did. Michael is a professor of political science here at UBC. He holds the Canadian Research Chair in Global Politics and International Law. His work focuses on outer space, Arctic sovereignty, climate change, the law of the sea, the laws of war, and the Canadian foreign and defence policy. He's a co-director of the Outer Space Institute, and indeed, Michael ran a whole session with that institute here. I guess it was before COVID. It seems more recent, but it's definitely had to be before COVID, given the changes that happened. It was very successful, and I know that many of the collaborators with Michael are here. A number of them are here tonight. His most recent book, Who Owns Outer Space? International Law, Astrophysics, and the Sustainable Development of Space, Cambridge University Press, co-authored with Aaron, who's here, Aaron Boley, who's also at UBC. His previous book, International Law and the Arctic, again with Cambridge, won the Donner Prize, and Michael is a regular contributor, as many of you know, to the Globe and Mail. Without further ado, welcome, Michael.
I'm conscious that not only do we have a large and friendly audience this evening, but there are also people watching the live stream. So I should say hi to my father and my wife and at least one of my children. That's what makes me nervous, not any of you. It's important to say at the beginning of such events that we acknowledge that we are on the unceded and unsurrendered land of the Musqueam people. I have added the word unsurrendered to make what I regard as an important legal point. I live on Salt Spring Island, which is outside of the Musqueam territory, but still on the land of the Coast Nations of this beautiful part of the world. I started writing a very academic lecture about international law a couple of weeks ago. I was going to tell you how international law is ubiquitous. I was going to tell you that international law has waxed and waned over the centuries. I was going to talk about how international law is going through a stressful period, and then explain not only its resilience, but reasons for its resilience. It would have been the sort of article that would be published in a journal that none of you would read. So I deleted that document a day ago, and I started again. And I decided to tell you about international law through my life with international law. Now, this is a bit about me. In fact, it's a lot about me, but it's not about me, in that I'm actually talking about law through what I know, what I've done. So please don't take it as in any way self-promotional. It's just I'm talking to you from what I saw. My initial realization that there was something called international law was from when I was 16 years old. I was an avid reader of our local newspaper, the Lethbridge Herald in southern Alberta, which was a fine newspaper back in 1982. And I'm looking at my friend Ricardo, the Argentine Consul General in Vancouver, to say that my first realization of international law came because of the war over the Malvinas Islands. Is the British Consul General here? Because they are also called the Falkland Islands. And it was an armed conflict. There were ships being sunk and missiles being fired and a lot going on that could attract a 16-year-old, but there were also some incongruities that struck me as interesting, as relevant. It was a dispute over sovereignty, going back centuries. It was about history. And because it was about history, it was about imperialism, colonialism. And it was also, at least from the British position, about self-determination. And I didn't understand the irony of the claim that white settlers from Northern Europe would have a right of self-determination over an island in the South Atlantic. But it was a curiosity that remains with me today. And it piqued my interest in not just war, but diplomacy and law, and the fact that even countries that are killing each other's soldiers in large numbers are still making legal arguments. That it's not just about power, it's not just about guns, it's also about rules, or at least claims based on interpretations of rules. Fast forward to 1988, and I was a first-year law student at McGill University, taking an introductory international law course from someone who was very familiar to UBC, a very young professor at the time named Stephen Toop. It was his first course. He was very green and very idealistic about international law and especially about human rights. And so I learned about international law from Stephen Toop. I learned about the different kinds of international law, about treaties, about customary international law, about general principles of international law. But the thing I took away from it, the really important thing, was that it was okay to be idealistic about the potential of international law. Thank you, Stephen, who remains a good friend today. Fast forward to 1992. I'm a summer student in the legal office of the Department of External Affairs in Ottawa. It's now called Global Affairs Canada, although the division, the legal division, is still called JLO. I had a fantastic boss, a man named Bob Haig, who told me on my first day that because I was only going to be there for 2.5 months, he was going to make it interesting. He already knew that I was headed off somewhere else at the end of that summer. And boy, did he make it interesting. And one day he called me into his office, and he handed me a thick document from the U.S. State Department. It was a document that had been circulated to all of the embassies in Washington, D.C. It was the State Department's legal analysis of the question, could they return refugees to their country of origin from the high seas? This was the first wave of boat people coming from Haiti to Florida. And the legal opinion, the very lengthy legal opinion, was entirely convincing on first glance. But my boss, Bob Haig, had been dealing with the U.S. State Department for many decades, and he knew not to take things at first glance. And so he handed me the legal document and said, I want you to check out this document, see whether they did it correctly, and come back and tell me what you find in 2 days. I'm still friends with Bob Haig. And lo and behold, I discovered that the legal analysis that was done by the U.S. State Department employed a little bit of a magic trick. They had to interpret Article 33 of the 1956 Geneva Convention on the Status of Refugees, which sets the principle of non-refoulement. Loosely translated as the obligation to not return, to not push back. And instead of following the order of treaty interpretation, the rules of treaty interpretation, as set out in the Vienna Convention on the Law of Treaties, they went straight to the negotiating documents for the Geneva Convention. And there they found evidence that the obligation only kicks in if the refugees reach your soil. But they weren't allowed to go to those negotiating documents, because you can only go to those negotiating documents if your analysis of the rules according to the object and purpose of the treaty, the ordinary meaning of the terms, leads to a conclusion that is ambiguous. And if you walk through all of the rules of treaty interpretation, you came to a conclusion that was absolutely clear, that the obligation to not return, because it's a human rights obligation, is to not send people back to persecution, period, whether it's from your soil or from the high seas. And so I went in and I told Mr. Haig what I had found, and he said, good, that's what I thought. You now need to write a legal opinion showing how the Americans are wrong. And you have to send it to me in 2 days. That legal opinion went through many iterations. When Bob Haig was happy with it, he sent it up the chain of command. I know, because I was able to follow it, that it went all the way up to the deputy minister. And then the deputy minister sent my legal opinion to the Canadian ambassador in Washington with instructions to take it to the State Department. I don't know for sure, but I have reason to believe that the Americans were not impressed with my legal opinion. And it is rumored that their response to the Canadian ambassador was, if you think there's a legal obligation to not send these Haitians back to Haiti, why doesn't Canada take them? My legal opinion disappeared from the face of this earth. The Canadian government didn't want 200,000 additional Haitian refugees in Montreal, didn't want to be the only country providing refuge. And so, in public, the American legal position went unchallenged. It was an important learning point for me about international law, because it's not just the law that matters, it's also the politics. And sometimes when it comes to human rights, state interests take priority. And every time I see the Italian or the Greek navies and coast guards returning desperate people to the coast of Africa or Turkey, I think back to the summer of 1992. Maybe we could have changed the world in a better way if Canada had actually stood up to the United States rather than accepting the American position. Anyway, I went at the end of that summer to Cambridge University to do a PhD on international law. I wrote my thesis on what I had just witnessed, namely on power and inequality in international lawmaking. And to this day, I have an ongoing interest in the politics and strategies of international lawmaking. The Americans were employing a strategy. They were putting out their preferred interpretation, dressing it up to make it convincing, and then challenging countries to implement on their behalf if they wanted to feel differently. In 1998, I was a postdoctoral fellow at another fine British university named Oxford. And I happened to be working on a fairly technical issue that related to human rights. I was exploring whether the American approach to asserting extraterritorial jurisdiction over human rights violations by people the country didn't like could be expanded to the law in England and Wales, something called the Alien Tort Claims Act in the United States. I was exploring whether there was room in existing English law to develop such a doctrine. And while I was doing that, I was in contact with a number of human rights organizations in London. And so when General Pinochet, Augusto Pinochet, was detained in October 1998, one of the lawyers from one of these human rights organizations phoned me and said, "We're having a meeting in 2 hours, can you make it?" I used to be a pretty fast runner. I was really fast on that day because I had to run to the train station in Oxford to catch the train to make that meeting, and boy did I want to make that meeting, because those human rights organizations intervened in what became known as the Pinochet case. And they very wisely engaged the best international lawyer in the world at that time. He sadly has passed. His name was Ian Brownlee. He happened to be the professor of international law at Oxford, and he quite literally allowed me to carry his bag into the House of Lords for the legal proceedings. I knew nothing, but boy was I learning. And I think we all remember how the Pinochet case ended. It ended with Pinochet being declared mentally incompetent to stand trial and being sent back to Chile, whereupon he experienced a miraculous recovery. Politics again. Tony Blair intervened and sent Pinochet home. But I saw something really important during those proceedings. First of all, I actually got to meet victims of the Pinochet regime, people who had been tortured. These were the first victims I properly met because they all wanted to testify against Pinochet. And there's something about a torture victim that stays with you forever. There's a kind of deadness in the eyes. It's one of the worst things that could happen to a human being, is to be put through extraordinary pain deliberately by another human being while you are totally helpless, while you are a prisoner. It's not just the pain of the physical torture, but the pain of knowing that another human being values you not at all. And that left a deep impression. It turned me into that idealist that Stephen Toop wanted me to be. But I saw something else. During the proceedings in the House of Lords, the eyes of the world were on the legal chamber. There were more than 100 television cameras outside. Ultimately, it didn't matter whether the human rights organizations won or lost the case. By detaining Pinochet, by making him subject to legal scrutiny, they had exposed to the world that there was a legal question surrounding him and his terrible history. The Pinochet case isn't remembered because Pinochet went home. It was remembered because a former head of state was made to answer in the highest court in one of the more powerful countries in the world. That was a lesson. It's not just about winning. It's about educating. It's about changing people's minds. I, very shortly after that, moved to the United States and became embroiled in some of the legal issues that arose after 9/11, after the terrorist attack on New York City and Washington. I publicly, very publicly, in the Guardian newspaper, objected to the U.S. government sending Afghan detainees to Guantanamo Bay and depriving them of the rights of prisoners of war. I objected equally forcefully and publicly when the United States argued that they were not violating the prohibition on torture because they were not causing permanent organ damage to the people they were interviewing. So waterboarding, according to the Americans, was okay. There were a couple of people who had experienced waterboarding who objected to the U.S. position. One was Senator John McCain, who had been tortured in northern Vietnam. And the other was a Vietnam vet who reached out to me, not as high profile as Senator McCain, but he said something that was really interesting to me that informed me about international law. He said, my captors in North Vietnam violated the Geneva Conventions. They tortured me. But if it was not for the Geneva Conventions, they would have killed me. It's not about perfect compliance when you're talking about international law. It's about the compliance pull that causes people to do slightly less evil than might otherwise be the case. And then, of course, the other remarkable thing was that the prohibition on torture and the Geneva Conventions survived the George W. Bush administration. Even the most powerful country in the world, led by an administration intent on violating international law, the rules withstood that challenge. So you don't need perfect compliance, and if the rules are deeply embedded enough in the global conscience, even the most powerful cannot do away with them. We'll come back to that shortly. And then I moved to Canada, and here to UBC. In 2005, I was speaking out very publicly, very forcefully, about Canada's behavior in Afghanistan. Because Canada was acquiring Afghan detainees on the battlefield and handing them to the Americans. And then after the photographs emerged from Abu Ghraib prison in Iraq, The Canadian government realized they really shouldn't be handing these detainees to the Americans. They started handing them to the Afghan intelligence services instead, which probably wasn't much better and was certainly illegal, because there was very good evidence that these people were being tortured in an attempt to extract relevant information for Canadian and American forces on the battlefield. So, in early 2006, I received a message from a friend of mine who had been a law professor, an international law professor at the University of Toronto for a good decade early in his career, and by that point in 2006 was Canada's Minister of National Defence. I'm referring to the Honourable Bill Graham. And Bill and I knew each other well and knew each other before his time in politics, and he was coming to Vancouver and he wanted to spend an hour or two with me. I didn't know why. It wasn't entirely social, at least that's what I suspected. And I invited him to come and speak to my class. I was teaching a class on the laws of war, and he appeared, and they quizzed him. And then, being a gentleman, he took them all out to Kerner's Pub for a beer. I mentioned Bill Graham because he grew up in that big house over there. This was the Graham residence when he was a child, a Green College connection. But the most significant part of that visit, because he was the defense minister and he was obviously constrained on how much he could say or what he could respond when speaking with me or my students, the most important moment in that entire couple of hours involved his wife, who pulled me aside at one point and whispered in my ear, "Keep pushing." And I looked at her and I said, "Keep pushing what?" She said, "You know what I mean. Bill wants you to keep pushing." Because the Minister of National Defense, as a former international law professor, didn't like what the Prime Minister was telling him to do and what his generals were telling him to do. He actually wanted us to stop transferring detainees. And I realized that international law sometimes constrains cabinet ministers, or not, depending on the circumstances. Around the same time, I was invited to be a visiting professor at Tel Aviv University in Israel, which has its own international law challenges. And I taught a course, a 1-month-long course on the laws of war. And the Israeli Defense Forces paid me a compliment or did me a favor, in that they instructed all of their young lawyers to take my course. And so I'm teaching a class, and the entire back row is made up of the young lawyers from the IDF, and we're talking about the laws of war. They were great students, because they were living it, right? And we disagreed on lots. But at the end of my month in Tel Aviv, they invited me to have lunch with their commander. And she was remarkably forthright. In fact, she must have broken the Israeli equivalent of the Official Secrets Act, because halfway through the lunch she said to me, "Next week we're going to destroy Hezbollah missile facilities in southern Lebanon. What do you think?" I'm not Israeli. I have no security clearance. You really shouldn't be telling people about your military plans. But I can keep a confidence, and I can provide advice. So I said to her, "You want to destroy these military facilities, these missile sites, because they're being used to attack northern Israel, correct?" She said, "Correct." And I said, "Good. Now you know just as much as I do that the laws of war require that you respond in a necessary and proportionate manner. So the simple answer is, as long as you confine your responsive strikes to those missile facilities and don't bomb anything else, it's okay." And she smiled and she said, yes. And that's exactly what I told the generals. So obviously a week later, I'm following the news very closely. And guess what? They only strike the missile facilities. Everyone's happy. 2 years later, she had left the Israeli Defense Forces. She went off to become a professor at Harvard Law School. And I don't know whether it was her absence or some other change in personnel or politics, but Israel attacked Lebanon again. And in 2006, they struck thousands of targets that had nothing to do with Hezbollah. They exceeded the constraints of necessity and proportionality. And I tell you this partly because the identity of the individual decision makers matters. The local politics matters. That countries that will comply with the law 1 year will blatantly violate it 2 years later. And Benjamin Netanyahu is an individual who is currently doing enormous harm. Individuals matter. So we're fast forwarding here to the atrocities of the 7th of October 2023. And what happened in southern Israel on that day was a grotesque violation of international law, multiple violations of international law, crimes against humanity. I hope all of those Hamas terrorists, if they're still alive, and their leaders end up in The Hague in the International Criminal Court, because they deserve to be brought to justice. So no apologies for Hamas. But what has happened since in Gaza also exceeds any conception of necessity and proportionality. Any distinction between civilians and combatants has been forgotten, has been blurred. And the suffering that has been imposed upon millions of innocent civilians is also a grotesque violation of international law. Two wrongs do not make a right. And these are difficult times for international lawyers to see these mass, multiple, grotesque violations. But I take hope in this context, and that international law is still providing a lens and a language for scrutiny, for concern, and for other forms of influence. And sometimes international law provides a venue for scrutiny. And I celebrate the fact that South Africa has taken Israel to the International Court of Justice under the dispute settlement provision in the Genocide Convention. And I celebrate that Israel has sent its lawyers to defend itself. I'm celebrating both South Africa and Israel, because international law has provided a venue for scrutiny, for evaluation. I don't know what the court will decide. I can say that I wish that there was a mechanism that South Africa could have taken Israel to the International Court of Justice to probe allegations of war crimes and crimes against humanity. The only instrument available was the Genocide Convention. So the only instrument available evokes the worst of crimes and touches very deep emotions, traumas, not just for Israelis and Jews, but for many people around the world. They had to use the Genocide Convention because there was nothing else. But the scrutiny of what is being done is still very valuable. And again, I celebrate the fact that Israel has sent its lawyers, extremely good lawyers, to actually make its case in defense. Because that is what courts ideally do, is that they hear both sides, that they ask questions, that they probe, and then, and only then, do they issue an authoritative decision. Okay, I don't want to take up too much more time, because I want to get to questions and discussions and hopefully disagreements. But I do want to talk about my move to Canada in another regard, in that having spoken very publicly against the Bush administration, I burned out in the United States. You can only receive so many death threats before it's time to leave. And UBC provided a very welcoming and peaceful place for me in 2004. And I switched my attention to the oceans and to the Arctic. The oceans are interesting because the law governing the oceans dates back centuries. In fact, the father of modern international law, Hugo Grotius, wrote his most famous book on commission to the Dutch East India Company about the freedom of the seas. So the oceans are about as far back as you can go in international law. And I was moving home to Canada, which has the longest coastline of any country. We are the ultimate maritime country. The longest coastline because of our 3 oceans. And the Arctic, of course, is where most of that coastline is located. And I was interested in the Northwest Passage because it's about the law of the sea, it's about indigenous rights, it's about US-Canada relations, it's about sovereignty, it's about security, it's about climate change, it's about Russia. I got to know Russia pretty well. I made multiple trips to Russia because they are, along with Canada, the great Arctic country. And I discovered that even when you're dealing with an autocratic regime led by someone as calculating and cynical as Vladimir Putin, who I've actually met and would never turn my back on, that if you can identify shared interest, you can still find ways, opportunities to coordinate and even cooperate. And so on things like search and rescue, or the delimitation of the seabed in the Central Arctic Ocean, or co-fisheries management in the Central Arctic Ocean, or in the Barents Sea, there was and remains a functioning relationship with Russia that is based on international law. That if you find those areas of self-interest in a place like the Arctic, you can still be supplying weapons to Ukraine and imposing massive sanctions at the same time. That international law enables you to walk and chew gum concurrently because the cooperation is based upon rules. And rules are meant to continue to guide behavior. I was surprised. I was encouraged. And I remain encouraged today. A couple other things I discovered when I started working on the Arctic is that sovereignty is a frequently invoked rhetorical move by domestic politicians. I watched for years while Stephen Harper talked about the threat to Canadian Arctic sovereignty while doing nothing to protect Canadian Arctic sovereignty because he knew that Russia already owned half the Arctic and wasn't about to invade Canada to gain more unnecessary Arctic. But boy, did it resonate with people. And the amount of time that I spent trying to talk people down from this red scare to point out the opportunities that were being taken for diplomacy and lawmaking in places like the Arctic Council. Sovereignty. I'm looking at Ricardo because the Malvinas were a bit of a move like that too, both for the junta and for Margaret Thatcher. Domestic politics. And the other thing I saw in the Arctic, as early as 2004, was climate change. Climate change was and remains more advanced in the Arctic than just about anywhere else on the planet. And I realized very quickly that because of feedback loops, like the feedback loop of melting sea ice exposing more dark ocean that absorbs more solar energy, that melts more ice, because of methane emissions from melting permafrost, that even in 2004, that we were staring into a very dark future. It's 20 years ago. And I was very frustrated because even though I could see that climate change was the greatest issue of my generation, that I couldn't get to grips with it in terms of international law. I wrote one long piece on the potential for using U.S. domestic courts in nuisance and tort cases to make damage claims against major carbon dioxide emitters like Chevron and Exxon. I like to think, and citations suggest that article had some impact, that there are now people and municipalities taking those big companies to court. But I'm not a U.S. domestic lawyer. I was outside of my expertise in writing that piece and in co-authoring that piece with two other colleagues. So the big thing I take in terms of my work from the Arctic and climate change is actually that I learned how to talk to scientists and listen to scientists, to speak their language. I collaborated with two remarkable people, both sadly dead before their time. Louis Fautier, a great marine biologist, and David Barber, the world's greatest physicist on sea ice. Dear friends who taught me about their fields. But again, I couldn't get to grips with climate change as my subject. And then in December 2015, my elder son Cameron persuaded me to take him to Cape Canaveral, Florida, to see a space launch. It was the first successful landing of a Falcon 9 first stage, and it changed the trajectory of my career. Because I realized that SpaceX and Elon Musk had just changed human transportation in a significant way, that reusable rockets would dramatically reduce the cost of spaceflight, and this would open up all kinds of development in orbit and beyond. And so I started reading about science, and I got really excited because I started reading about space and got really excited because, among other things, there was lots of science again. Science I didn't understand. I thought orbits were all circular. But, I can learn. I also discovered there was lots of existing law. The Outer Space Treaty from 1967, the Rescue Agreement, the Liability Convention, the Registration Convention, the Limited Test Ban Treaty. I mean, the list goes on. And I could get to grips with space in ways that I couldn't get to grips with climate change. And lots of rapid changes, driven by some of the most powerful actors in the world. Right? The United States, Russia, China, India, Elon Musk, Jeff Bezos. Some of my students are in this room today. Some of them wrote essays in a test this afternoon in response to a question: is SpaceX a great power? Yeah. And so there was all kinds of potential. And then I met Aaron Boley, who's seated right over there, who is an astrophysicist, which is as far away as you can get from international law and international relations, and found that I could actually understand him and that he could understand me. And we've been working for the last 6 years or so on a number of massive emerging challenges in near-Earth space, in that part of space that humans can get to. Light and radio pollution from satellites interfering with astronomy and with nocturnal animals, and just general enjoyment and access of the night sky. Collisions and debris in orbit, collisions between abandoned rocket bodies, abandoned satellites, sometimes still operational satellites. It's turning into a bit of a garbage dump up there. Re-entry risks from rocket bodies. There are Like there are all kinds of massive rocket bodies in orbit, and they're all coming back one day. Some of them are 20 tons, right? So re-entry risks from all the stuff we've put up there. And then also the weaponization of space and the current jockeying for position between the United States and China and Russia. There's a lot going on in space, and yet there's a lot of law and a lot of opportunity. And guess what? It brought me back to climate change. Climate change in a way that I think I can actually help with. In that 3 years ago, Aaron identified that these thousands of satellites being put into low Earth orbit, which are intentionally designed to re-enter at the end of their short operational lives, is going to dramatically increase the number of human-injected particulates into the upper reaches of the atmosphere. So just imagine thousands and thousands of big aluminum satellites burning up. Mass doesn't disappear, right? They just turn into billions of particles, and they're deposited in the upper atmosphere. It's like a geoengineering experiment, except it's not, right? It's just a business plan. And there are also, of course, atmospheric changes resulting from all these rocket launches. A lot of black soot going into the upper atmosphere. For instance, we did this back in 2021. Aaron's idea, we put it in an article we published that, as of yesterday, had 47,000 views. It's had a bit of an impact. And there was a German team that published a similar analysis at the same time, separately from us, without our knowledge. And sometime about a year ago, some NASA and NOAA scientists, some scientists in the United States, government scientists in the United States, decided to find out whether Aaron's suspicion was indeed valid. They took a high-altitude aircraft up to 60,000 feet over Alaska in March of 2023. And they sampled the air, and at that time of year over Alaska, the stratospheric air is pushed down. So they were actually sampling stratospheric air, and they ran it through a mass spectrometer. And they found all kinds of stuff that shouldn't have been there, right? Including some obscure alloys that are only used in the nozzles of rocket engines, right? They found a lot of aluminum, and the influx of aluminum particles from meteoroids is really small, so there's a lot more aluminum than there should be. Thank you, NASA, right? It was like they did our research for us, because we don't have a high-altitude plane. Aaron would love to have an high-altitude plane. He doesn't. But we have this now, and so part of what we're struggling with, and it's very exciting, is struggling how to take this and turn it into sort of the mainstream consciousness, to get it into the minds of decision makers, to make sure that climate activists are aware that the climate's being altered, both from what we do on Earth and now what we're doing in space. And yet, here we can do stuff, right? Because we have a lot of international law, we have a relatively small number of actors, and climate change is a massive collective action problem involving billions of actors. Space activity caused climate change is happening as a result of just a few actors, right? Just a few actors, handful of spacefaring states and companies are potentially contributing to this problem right now. So, yeah, it can be solved, and law has a role to play. We've also taken on a whole bunch of other stuff. We've taken on the issue of the testing of ground-based missiles against satellites in orbit. A number of countries have blown up their own satellites in orbit to show that they can do that. Creates a lot of debris. We organized an international open letter on that. I cannot prove causation. But our international open letter was followed by a US-led initiative for now 33 countries to declare that they will never test missiles against satellites in orbit. One has to be really careful here not to claim that you've had an impact on law and politics, but it's a nice coincidence, and it makes me feel good. We also took the issue of reentries into a law-making effort. Did a workshop in Montreal in partnership with McGill University's Institute of Air and Space Law, and crucially with the International Civil Aviation Organization, essentially identifying by combining various disciplines and forms of expertise, disciplines and lived experience, that there is an increasing amount of space material surviving atmospheric reentry, and that a piece of debris as small as 300 grams could fatally damage a large civilian airliner. And that identification, which I attribute to my colleague Ram Jaku at McGill, that identification has got us leverage. And now, and perhaps it's a coincidence, we're seeing new lawmaking efforts internally within the United States through the Federal Aviation Authority and also in Europe. That doesn't mean you can fly without fear, but we're hoping to promote a regime, a legal regime, where one day rocket bodies are not abandoned in orbit, but are returned to the surface of the Earth in a controlled manner, so that they don't strike and kill someone. We're also in the early stages of a campaign to encourage some countries, probably from the global south, to seek an advisory opinion from the International Court of Justice on the issue of light and radio pollution caused by satellites and the damage caused to very expensive observatories in places like Chile. We're doing a lot, and it all involves international law and science and politics, and it actually gives me hope. Because when I see all the problems around the world and all the violations of international law around the world, I know still for a fact that international law is a tool that can be used in certain circumstances, when wielded skillfully and with careful timing, to influence the course of events. We can't do any of our space stuff without a knowledge of international law, the use of international law as a tool, just like you can't deal with massive environmental problems without some knowledge of law and justice. Like you can't advocate for human rights in a meaningful way without even using the language of rights, which is law. So I remain optimistic about international law. I encourage my students to learn more and to deploy their knowledge to do good. And then sometimes I'm greatly cheered up when I see something happen that most people would never expect, something that's based in international law. So in 1998, the United States and Canada and the Russian Federation negotiated and signed a treaty called the International Space Station Agreement. We built collectively the most expensive object that humankind has ever constructed, and we did it in low Earth orbit. There's a terrible war going on in Ukraine. Relations between the West and Russia are the worst they've been since probably the early 1980s, around the time of the invasion of Afghanistan, the Russian invasion of Afghanistan. And yet on Sunday, Russian cosmonaut Alexander Grebenkin climbed into a SpaceX Crew Dragon spacecraft on top of a Falcon 9 rocket at Cape Canaveral, along with 3 American astronauts, and was launched to the International Space Station. Now that's partly because wise people in Washington and Moscow have realized that the International Space Station does really good stuff, that this investment needs to be protected. but it's also the fulfillment of a promise based on a treaty that we're going to cooperate in space because it's in our mutual interest, and will continue to cooperate even when effectively we're at war. I took great joy out of this Russian cosmonaut being launched, and I will take great joy when in a few months an American astronaut is launched on top of a Soyuz rocket from the Russian spaceport in Baikonur, Kazakhstan. And I don't just regard it as cool. I regard it as a vindication of my discipline, that international law enables us to come together across borders even in the most difficult of times. So that's my story. There's a lot there, and I'm happy to take questions on anything. Happy to talk about Gaza. I'm not afraid to talk about Gaza, unlike many of my colleagues. So give it to me. We have about 40 minutes.
Just
30 minutes.